Okay, we are now recording the latest meeting of the Delinquency Performance Standards Work Group, which is back on track to create performance standards, not on the previously shortened timeline, but still the relatively short timeline of ideally end of August to get a draft out. I do have a process update based on how the criminal work group is moving forward, because the current agency plan is to kind of roll out performance standards one kind of topic area at a time. So we're um, disseminating draft criminal performance standards, I think, at the end of this week. Um, and those will go in front of the commission, but also out to providers for, I guess, like a 45-day feedback period. So I think we're going to send those out August 1st, and then September 15th we'll close comment, and then ideally incorporate comment, and then bring them back to the commission in October. And I anticipate that the delinquency standards will operate on the same schedule a month later. So we would disseminate early September, and then mid-October get feedback back that we then incorporate to probably bring back to the commission in November. Um, so we have now, because everything was rushed briefly, a prettier looking version of the document we were working with before, and also waiver standards, thanks to Liz and Nora, that are incorporated into that document. I will share the screen. I think for today, or I guess the next, I think we can have today and probably one or two more meetings, hopefully before the end of August, for whoever can make it, to get our last comments in here. Share screen. But I think the two main, I think there's overall, we could just go with what does anyone want to talk about on any of these standards, or I still think the big outstanding area that I still don't fully understand is JPAR, and some of the differences between JPAR and, I guess, criminal post-adjudication obligations, and also post-conviction, and how those all intersect. So the current draft standards have the language from the state bar in the post-adjudication requirements. And so we could turn there and talk about those as a group if we think that would be a good use of today's time, or I can just start scrolling through, kind of pick up. I think we had made it through at a group discussion, approximately standard 2 or 3. So we could just kind of go back to the process we kind of paused when we were rushing through before. Does anyone have opinions? If no one has opinions, I think it might be because you all have access to this document. And so I welcome and encourage you all to add comments in the Word feature, or email me if there's anything you think we need to talk about as a group, or you just want to highlight for me as something you think should be changed. But in terms of maybe group collaboration, it might be most useful to talk about the post-adjudication section. And then if we're all in agreement on that today, we can go back through and hit some other areas. So I'm going to scroll down to concerning disposition, post-sentencing, and disposition. So this is 9.3 and 9.4. And if I remember right, I think there was some stuff here that had, I think the current draft incorporates essentially 3 sources: the OSB standards, the Galt Center standards, and the kind of frame of an outline that Nora and KO had put together. and I just kind of compared all three and tried to make sure that there wasn't anything obvious, I guess mostly from the galt and the outline, that wasn't in some way addressed here, but I assume it wasn't. There's surely areas that could be addressed better. Um, I I think what I truly don't understand is the language in. Let me pull it up. But I think Ko highlighted this for me when she passed this off. The ongoing questions about obligations post adjudication. But the way that the statute says that basically on anything under 610, the judge can review any previous order, and then under 615 it says essentially what the post conviction like options are. But my understanding of JTB is that all of this happens in front of the original judge or the or original court. I guess maybe the judge would, if the judge retired, I guess there could be a new judge, but under that, in that same courtroom as the original adjudication, which implies to me that is the implication that the lawyer must always do post conviction. The original lawyer must do the post conviction if it's always available, and you don't need and there's no threshold showing required. Yeah, Matt.
I think depending on what I mean, if it's a post conviction like
Like IAC. Yeah.
IAC claim, then there's a clear conflict, and that attorney should not be having anything to do with
Right. I mean, I guess
that pursuit.
is it always available, and that someone should always do it? I mean, my understanding of post conviction in the criminal sense is you have to make a threshold showing to the court, and then if you clear that, then the judge could appoint counsel if you qualify. Whereas the implication of this and JTB, I think, is that you don't have to make any showing. So you could always get a lawyer if you asked for one, and if it's not an ISC claim, you would potentially already have one. So I don't know how that's supposed to work.
Well, so I don't think we are in a position in this group to solve the issue of how a youth gets from point A to point B on having let's say an IAC claim, and then getting an attorney and having that attorney investigate that. Like that's um an individual attorney just sitting in his or her office sort of isn't in a position to do much to get appointed in that circumstance. And
Yeah.
I know internally at YRJ we've spent some time talking about the procedure and what we should be advocating for to, I guess, make the procedure more clear on how a youth or now adult gets a court appointed attorney for an IAC claim, because it's not clear or straightforward.
Mm-hmm.
And it seems I guess I'll just leave it at that for now. But I mean, for a performance standard, you should, if we're talking about you've been assigned this case, what do you do? I think, you need to go, there's a whole list of things where you are as a starting place. If you get assigned a post adjudication relief case, and so I don't.
Sorry to interrupt.
Yeah.
And we talked about this a bit at the last meeting,
Mhm.
but is there it looked like you could ask for relief on any grounds under 610, but then separately, if you were under 615, it's like post conviction, and they lay out the constitutional violation or I guess illegal statute or something like that.
Yeah, I think
for those, it
okay.
seems like I could just import the post conviction standards into the 615 standards. And what I don't know is when people say JPAR, are they is the, I guess we should, I want to make sure that the standards reflect the understanding in the field and the practice. Well, I guess not the practice unless if we want to change the practice, but reflect what we think best practice should be. Um, in terms of uh, is is there a difference in how people talk about these two different ways you can ask for relief, and what is it? And if 610 is the other things you can ask the judge to change their mind about, when is that used? Sorry, this is all just you all educating me on how everything works.
So I see 610 as the court having the authority to modify any order previously entered.
Mm-hmm.
Sort of, I mean, adult criminal court sort of does too, but there are, I think, more firm timelines on some of that stuff. Um, but as within 610, it references grounds for set aside, and then in 615, it talks about constitutional violations or the statute having changed, right, or what have you. So, I mean, I guess if you if you're still the attorney, right, it's youth is on probation or whatever, and there's some issue that you are asking the court to modify, you would just file that, right, as the attorney. And I don't know that I would consider that like a JPAR situation. I mean, it kind of is, but you're still the attorney. I guess, and maybe this is just me, but I sort of view the JPAR as more tied more closely to IAC claims than just regular things that we're dealing with post adjudication. Um, and I think it's the relief is sort of what uh,
Mm-hmm.
because that's also the R in PCR, right?
Mm-hmm.
Even though
Mm-hmm.
you could get a PCR judgment in your favor for non-IAC grounds as well,
Mm-hmm.
for other substantial denials, your constitutional rights. Um, so at least in my eyes, I view it as more closely tied to PCR than other types of, I guess, post-adjudicative work.
Mm-hmm.
But I may not be correct on that, I suppose. So
Under 610, is it the case that, like, if you could ask just to say, well, the youth was adjudicated to a certain length of probation or a certain custodial period, and I want you to change that, and if that's, I see you nodding, does that mean that basically because of that availability, all attorneys should always be doing that at some point?
well, so it says any order, which can include the disposition, and it can include anything within the disposition. For example, courts, just using probation as an example, some courts will set a definite amount of time for probation, and some courts will say 5 years.
Mhm.
And then if you do everything, I'll enter an order
Mm-hmm.
terminating probation, which I think falls in line with 610 as
Mm-hmm.
where the authority would come from for the court to be able to do that.
Mm-hmm.
Maybe I'm wrong on that too, but um, if there is a condition of probation that your client finds onerous or circumstances change to the degree that justice or whatever should warrant merit that changing, I think then you can file that, and that's your authority, is the court has the authority to set aside any order that they've previously entered. Um, and yes, I think if your client calls you and says, "Here's my situation, can you help me with this?" and you represented that youth on that case, then I think you should do that. I mean,
Mhm.
Yeah.
so Nora, I don't know.
Yeah, I mean, it's
Yes,
also 610 is pretty broad, obviously.
Mhm.
And I think it it is also used sometimes in sex cases. And before the statute changed, leave before, and Liz, correct me if I'm wrong, because this may predate my Oregon time, that one of the kind of workarounds for registration was that you could file a motion to dismiss under 610 and or a motion to set aside, and in order to avoid registration for juvenile. And I think in that is still often done kind of in tandem with a registration hearing. You file both a motion to, for your client to be relieved of the obligation to register and a motion to set aside. And I think 610 can also be used if your client has successfully completed probation and you want to have the adjudication either set aside or drop down to a misdemeanor. I mean, there's just kind of a bunch of different ways that you can use it to get your client relief at the end of a case, or as you were just talking about, midway through probation, if your client has done everything they need to do and maybe, they want to move out of state or they're going to college or whatever, and you file, or for whatever reason, you file a motion to terminate early. I mean, there's sort of a number of different ways that you can use 610 to get relief, set aside relief for your client. And I think then 615 kind of lays out some more specific grounds that are more akin to a PCR,
Yeah.
which would be not just a set aside, right? But
Vacation.
but yes,
Vacating.
vacating. Yeah.
Yeah.
Because a set aside it's not like
Right.
the case doesn't exist anymore. Like it's still
Right.
there, right? Set aside is kind of this
Yeah.
legal. I've always had kind of a hard time in my head with set aside because it's a little bit of a legal gray area. But,
So I guess it seems like some of the things you were all talking about are things that are also available in the criminal context, as you alluded to, Matt, but maybe less directly as part of the original attorney's assumed obligation. I mean, some of them seem like they are, like maybe some of the probation related stuff. But then others, it seems like it would be like, I know, my wife who works at MPD does some of the stuff that is considered collateral because it's not, inherently part of the original attorney's obligation. And that, I think that's the area for the purposes of the performance standards we're talking about, like what should be written here as the baseline expectation for how long the attorney's obligation lasts, considering the availability of all the different types of relief and the fact that that relief would be granted, I guess, explicitly, according to JTB, by the original judge as part of the original adjudicatory process. Does the obligation extend further by the terms of 610 and 615, or is it more akin to it's optional, or if the kid reaches out to you and asks, then you should? I mean, these are all, I mean, I think because of this gray area and also because of what I recognize to be the funding challenges associated with this and what attorneys are actually paid to do, I recognize that that's a challenge, and most of the language about this is currently in the best practices as opposed to black letter section of the standards. But I still think we as a group should have I guess to the extent there can be a consensus about what the best practice is, it should go there.
I mean, I'll just say we're at PCRP county. Our contract requires us to stay on cases through the end of wardship. So we contractually we have to. So I know that's not the same for all contracts, non-PCRP counties, consortia around the state, what have you. I do think the reason it's in our contract is because it is the best practice to do that. And even without that in our contract, I know previous PD's offices, and I certainly, when I was in a consortium, would continue to help my clients throughout in terms of their probation. And I think ethically you probably should and maybe have to. So I think we should include that as best practices, certainly.
Yeah. I think it's definitely a best practice. The tension.
And does this, sorry to interrupt. Does that,
That's
when
okay.
you both are saying this, are you including the non-IAC parts of 615? Like if you would potentially, could you, like when I was handling post-conviction in Louisiana, if we got a PCR case, we would look at it for IAC, we would look at it for like, we need to get the DA file and look for Brady and send out an investigator to investigate Brady post conviction. Is that an expectation in all delinquency cases that you potentially engage an investigator for potential non-IAC Brady or other constitutional type claims?
Like if a client wants to seek post-adjudication relief under 615, like are you asking? What are the
Well, yeah.
obligations?
Well,
Yeah.
yes. Well, I mean, it sounds to me like you're all saying a lot of the things that are obviously available under 610, you should do. I guess you should be aware of and be willing to do. I guess the question is like, how much of it is like, I should make sure in my calendar to be going and asking my client, is this the thing they want? Versus if they reach out, then I'll do it. But it's not necessarily, I don't need to be proactive. And the availability of post, essentially juvenile post conviction relief without the need to make a showing. Someone could argue, well, that means you should always do it. But that's a huge body of work if you're doing that on every case, obviously, and not one that's currently funded. I think under PCRP.
I think that yeah.
But I don't know. But I don't know how to square that with the actual language in JTB and the statute, and it's just kind of availability.
Maybe I'm not paying enough attention, but I'm having trouble imagining a circumstance where like a full PCR, like your example of sort of reinvestigating the case with Brady, that didn't implicate ineffective assistance of counsel. I think maybe that's where I'm just confused about that. I will say with regards to the sex cases in particular, this is like in Washington County, I think this is their standard way of, avoiding registration hearings and a youth being successful on probation. That those practices vary from county to county because that's not the motion I file here usually if I'm trying to unwind one of those. But that's the longstanding practice in Washington County, according to my coworkers out there. So people use it for lots of different ways. But back to the post-conviction stuff, I think I have trouble imagining a circumstance where the original attorney could sort of ethically be the one reinvestigating it. Maybe I'm just missing something here.
I mean, really the only circumstance I could think of is if there was truly new information that came up after the adjudication. And then I suppose you could still be involved in that if even if it was unknown to the state or the state hid it or whatever, that you would not have been legitimately in a position to find that out prior to the adjudication. But that's such a, once in a decade or 2 decades or, that's not a thing that's going to happen very often.
Yeah, I mean, I think that what you're saying, Matt, was what I was thinking of. But it sounds like it looks like you're all nodding along with the notion that that's so rare, and because it would always be better to be kind of investigating all potential aspects of relief under 615, including ineffective assistance, it would always be better to have a different attorney. I think that's straightforward. I guess the challenge is like, because the youth doesn't know how to get it, is the original attorney under any obligation to like navigate that or raise it? And it sounds like that's not part of the practice. I'm not trying to overcomplicate things. I just want, to the extent we can be clear in the standards to.
No, but I can jump in there. I mean, I think if your client says to you or someone, and it gets back to you that they, have concerns over what you did, then you probably ought to. This is again where it gets murky because I don't think people know what the procedure is to get somebody appointed on a JPAR case, like would you refer it to OPDC? Would you refer it to the court? This is, I guess, maybe a question for OPDC. If the agency is going to appoint people for these, we probably need to figure out what that should look like so that cases can get referred. Because otherwise, I mean, we should probably put that in the performance standards, but I don't think anybody really understands how that is happening. Other than it seems like a clinic goes to McLaren and interviews kids, and that those get sent to OPDC, and then some of those get farmed out. That's my current understanding of what's happening. But if there was a more formal way to do a JPAR referral, then we could, like, if it comes to your attention, your client has an IAC claim against you, you have an obligation to then refer that so they can get an independent attorney to look at that. And I will say we have internal appellate attorneys at YRJ, and if we talk to our client after the adjudication and they want to appeal and they want to, I don't want to say blame us, but say that we didn't do a good enough job, like we will conflict off that appeal, and because you can raise IAC on direct appeal in juvenile court, unlike in adult court. So I mean, I think you have an obligation to figure that out a little bit, at least on the first level, right? Of do you want to appeal this? Do you want to include, my performance as part of your appeal? And I guess if you've cleared that hurdle, and then down the road, I don't know. I guess this is your question. Is like, do you have a duty to continue to investigate whether they want to make an IAC claim at some point? I don't. It's putting attorneys in a tough spot, I think, at that point.
Yeah, for sure.
I mean, I think one of the things that makes this particularly hard is the fact that juveniles go off to McLaren or go off to probation and they don't remember what they pled to. They don't. I mean, even at McLaren, I've had clients call me and be like, what am I on probation for? And I'm like, well, you're not on probation, and these are the names of the charges, and so, anything that requires the youth to affirmatively do stuff, I feel like is going to perhaps be ineffective completely, just because they're not going to, they just don't have the sort of skills to sort of realistically do that. I know that currently the practice seems to be that the law school clinic goes in and talks to youth and tries to answer questions. And even with that, sometimes the questions are like, well, yeah, I shouldn't have been convicted. And then so they get a JPAR attorney, and the attorney kind of looks into it and is like, well, I see what happened here, and perhaps you should have been convicted, or but it's kind of, anyway, it's a very convoluted thing. And as annoying as sometimes the clinic is, it does actually seem like it fills this niche for clients to sort of have some opportunity of some separate attorney reviewing their situation, just because the clients themselves are so confused and a little bit fragile. So I don't know how we solve the problem other than, because I also agree with Matt. I think some of this is sort of impossible for the original trial attorney to be the one to really address. So.
Yeah.
Well, it sounds like there's, separately from the performance standards, processes that need to be improved that I can flag for OPDC apart from the performance standards. So, and maybe to help move the conversation along today, what we need to answer is, I guess, whether the language in the standards that talks about an attorney's obligation post disposition is adequate to capture what the, I guess, immediately available and standard work that everyone understands to be for helping a youth through the next steps after they get the adjudication.
Yeah, and it's basically two sets of standards. It's the post adjudication work generally, and then if you get a JPAR case, that there's a separate sort of set of standards on what you need to do on that case, right? Sort of like,
Yeah, and
if,
so
if you
those I
if you're
think are
appointed a PCR case, like this is what you
yeah.
do.
Mhm.
Those are not
Yeah.
so I guess I should say I don't believe that anything in the current draft addresses that based on my fuller understanding after this conversation. I don't think there's anything in there that looks like what ought you do in a post conviction case. And I don't know if any of y'all, I guess a couple of Matt, you've maybe handled a couple of these. Do you believe, like, is there a meaningful difference between, like, there are OSB PCR standards, and a different work group is talking about PCR standards. If once they're done, should I just be taking that and saying also know how to talk to your youth client as part of that?
Yeah. I admit I haven't studied the adult PCR standards recently. They probably need to be modified somewhat to apply to juvenile cases. There needs to be obviously knowledge of brain development and all the things, and whether that was addressed by the trial counsel. And
Yeah.
often, the majority of the cases, just like adult PCR cases, are from kids that are at correctional facilities. And so they tend to be on more serious cases where there's, usually a lot more work to do. And then whether that was been done or not, or even looked into, and all, sort of all that stuff. So, um, I guess we probably, well, yeah, I don't know if we include that and then modify it makes the most sense, or so that it's at least as closely
Well, why don't I try to
connected.
get
Yeah.
for our next meeting, I'll try to get the current draft of the PCR standards. And maybe for this meeting, we can look at the non 615 related language, which I think is what should be on screen, I think was intended by the OSB work group to capture a lot of what I think 610 covers. And so that has methods for filing for post-disposition and post-adjudicatory relief, sex offender registration, motion to set aside, adjudicative and dispositional orders, helping with youth whose health, safety, and welfare is at risk, presumably in the facility, fixing sentences, motions for early discharge, dismissal of commitment, early release from detention, modification of the court order, and then how to handle indeterminate sentences. Is that language broad enough? Does it leave things out? Is it too broad? I was reading through the sub 3 there. That should be on the screen.
Hmm.
I can make this bigger.
I think that's,
Sorry.
no, that's okay.
Look like some of you have thinking faces on, but I don't know if we should move on, or if
No,
you're all
I
still
think
processing.
I think that's good.
Okay.
I think we're
So
going to get a lot of pushback in the counties where it's not funded, obviously.
well, it's an important conversation to have. So
Yeah,
and it's, again, it's a best practice.
sure.
And I did put, I don't know if any of y'all saw, I took the language that we drafted for the criminal standards
Mm-hmm.
in the intro,
Mm-hmm.
that talks about how not all standards will apply in all cases, and in some cases they're probably mutually exclusive to
Mm-hmm.
adhere to all standards in all cases. So there will always be some exceptions. Of course, inability to do something because it's just not funded is a separate issue, but
Yeah.
important to have the best practice there. Then this, I think, this 9.4. I forget if this was a version of this was already in the standards, or if this was imported from somewhere. And I assume the same caveat, Nora, applies here, that
Yeah, it
presumably
does.
be pushed back.
Yeah. And I think I mentioned this before. In my experience, I think there'll be pushback from providers. I think there are also some logistical hurdles that are put in place by juvenile departments in other counties, at least in my experience, where the juvenile department will not let you advocate, like will say, I'm not going to talk with you because your appointment has been terminated upon disposition, and you don't represent this child anymore, even if you say you can't tell me who I represent. Um, I've encountered that in Jackson County specifically, where they just are absolutely adamant that I cannot.
Yeah.
They just won't interact with me at all post disposition, which makes advocating
Well, I
for
guess, is
difficult.
it,
Yeah.
other than,
And
I
the
mean, it seems
court,
like having
yeah.
this here at least would be some
Oh,
small bit of help
yeah. No, I mean,
for you.
I cited to the I think to the OSB standards about post disposition advocacy, and they were like, we don't care.
Yeah. Does that
County
impact?
council said we don't care. So yes, hopefully this would help. I think ultimately it's got to be that, courts start continuing appointment, but that's not going to happen unless there's
Yeah.
lawyers aren't going to be willing to do it without funding. It's kind of this whole circular thing. So anyway, yes, I think it's good. I think
Okay. None of that
there
should
are
change anything that
logistical
we're, yeah.
challenges system wide.
Okay. Well, then would it be helpful to keep going now and talk about the waiver language that Nora and Liz put together? Just get some other eyes on it.
Sure.
Or we could go back kind of earlier in the document. But Liz and Nora, when you sent it to me, you said that edit liberally. I don't really think I don't remember doing very much other than maybe formatting, but
Okay.
or reviewing for typos, because I certainly wouldn't pretend to overrule your opinions on substance.
Well, then we are happy to accept feedback, editing, wordsmithing, substantive modifications, whatever.
Yeah, we were going through this pretty fast.
Mm-hmm. And it was an exceptionally hot day, and I was in my attic without AC.
Is waived youth a term of art? Should this W be capitalized, or
Oh,
I don't
that's
know
a
if
good
I did that,
question.
or
I mean, it is in Oregon kind of a term of art because it's a youth, but it's also, it's a youth who has been waived. I don't know if if it merits capitalization.
Yeah, we aren't capitalizing waiver
Yeah,
elsewhere, so it seems
I
like
think I probably
it should
wouldn't.
probably be lowercase. Yeah. I'm just going to scroll slowly. The standard 10.2 about informing the client is, am I right that that is just because clients should know what's happening? There's not like a choice, like the state makes the choice. Is that right? And the child
Yes.
is then has to do, has to defend.
Yes.
So it is you ought to know that this is a thing that could happen,
Mm-hmm.
and
Yeah.
and this is how we will handle it if they do it. That's
Yeah.
the point of 10.2. Okay, just wanted to make sure I was understanding.
And I think, when we were reading through the, gosh, I can't remember if it was NJDC or NCDC, whatever standards we were looking at. I think it was the GALT standards. They have some comments in there about advising your client, and clearly following clients' directives. And I know there were a couple of places where Nora and I kind of discussed, because you're always going to be acting at your client's direction under the rules of ethics, but you also have to explain it clearly and in a way that your client will understand. And the GALT standards really sort of just kind of assume you're objecting to waiver. And there are, I will say, very limited circumstances, but there may be circumstances where, for all sorts of reasons, your client wants to agree to the waiver. Seems like that might not be a good idea, but I'm sure that there are circumstances when a youth might do that. And so we just needed, it needs to have this sort of space for that option to sort of come through. Even no matter how rare that circumstance might be.
Mm-hmm.
Yeah, that makes sense.
Can I just throw something in on for 10.24C?
Mm-hmm.
So it's the overwhelming disadvantages along with limited advantages to proceeding in adult court. I guess the overwhelming is getting me. I don't know why I'm nitpicking on that, but
So these are the kind of comments we want.
Right.
I mean, I think consequences certainly. I don't know if that's baked into the overwhelming, but from actual litigation, I think there's actually kind of a lot of advantages in adult court that aren't in juvenile court.
I mean, you get a jury
Most
trial.
you get a
Juries.
jury. Yes, that is extremely significant. And I mean all of the balancing, like the character
Yeah.
evidence balancing, like
Mhm.
all the evidentiary issues that kind of get swept under the rug when you have a judge trial, are just like sort of glaring display in an adult criminal case. Oftentimes to the benefit of the defendant. So
Would you prefer a more
I just a
less? I mean,
little more neutral. Yeah.
just taking out any judgment from just leave it as advantages and disadvantages.
Yeah, I think so. I don't know. I don't know if it needs the commentary, I guess, like the implicit commentary on that. The consequences, to be sure. And I don't know. I think we talked. I don't know if you want to throw something in there, and I guess that's part three. Um, but yeah, I don't know.
I mean, I think, like I said, when we were reading the rules we were using as guidance, they very strongly prefer, don't waive, but
Well, yeah,
there are circumstances where it might be entirely appropriate. Um, and it is true, a jury trial is a different animal and there's a lot of benefit to it. And despite the judges who say, "Oh, I can completely tell the difference between admissible and inadmissible character evidence because I went to some magic training that taught me how to do that." Um, yeah, so I mean, it makes sense to just say advantages and disadvantages or however.
yeah. I think the potential sentences far outweigh
Yeah.
everything else, and so
Yeah.
it's that. I mean, it just if you're thinking about it when you're representing youth, I mean, obviously we try everything we can to keep the youth in juvenile court.
Mhm.
Full stop, right? Like, except as Liz is talking about, if we could all come up with scenarios where you might agree to it,
Mhm.
but
Yeah.
yeah, the actual litigation part of it, says a man who used to do a lot of adult criminal cases and somewhat wistfully in
Yeah.
remembrance of how it used to be.
I think that's for all of us.
Okay, any last objections to taking out the modifiers here?
Mm-mm.
All right. There's capitals. Pros and cons. Isn't that like, is that formal? Should it say, should I change that to advantages and disadvantages, or do we think pros and cons is okay in the performance
I was
standards
wondering
context?
about that actually when we were doing this. I would advocate for advantages and disadvantages.
Yes. I was not, as I was typing this, I was not paying attention to sort of consistent phrases. So, yeah.
I read it before and it didn't jump out, but then now I'm like,
Mm-hmm.
And then looks like sometimes we capitalize. I think generally we've been not capitalizing state. Keep going back and forth, but I think I'm
I
going to
think that that's
lowercase it.
right.
As the person who was typing as we were doing this, yeah, change anything because I was not paying attention to
I mean, I think I
any of that.
suspect that even at the end of this whole process across all the different practice types, we're going to get that one in particular. I think we're going to see a lot, like state, sometimes
Yeah.
capitalized, sometimes lowercase, even within the same document. What about here in 1? Is juvenile court capitalized, or should I lowercase the J there?
Oh, God.
I think lowercase j. If you're going to capitalize the J, you should capitalize the
Capitalize the
C in
C.
court. Yeah.
Yeah,
I'm on that
agree, but I think
bandwagon.
I think it's been
I
lowercase
think that's fine.
elsewhere. Right. Any other input on the waiver standards? Great. So I will re-upload this document with these edits back to the Dropbox, and I'll send out another doodle soon so that we can do, like, hopefully either in 1 or 2 meetings in August, a final pass through of everything. And then, like I said, it is going to go to the broader provider community. This isn't, I mean, we are going to put it in front of the commission, but when we do that, we're going to say it's also going to providers for feedback before we ask you to vote on it. So we'll certainly hear both substantively what people think, and I'm sure also whether they think some of these practices are realistic in all jurisdictions. But feel free, like I said, to email me specific thoughts, suggested edits, or put those comments directly on the document, and we can talk about them at our next meetings.
Hey,
Great.
Colin, I have a weird question
Yep.
that just occurred to me. The opportunity to provide comment about these standards, clearly the providers will have that opportunity. Is OPDS doing anything to solicit feedback from the courts? And the reason I ask is that in some of, especially these small jurisdictions, the judges have very strong opinions about how this all should happen and what sorts of things lawyers should be expected to do or not expected to do. And so some of this, I'm curious what, if it's sent to the courts, I wonder if there's going to be some strong feedback from some judicial officers, who knows where. I'm just curious.
I am not positive. I believe, well, the criminal ones haven't gone out yet, but I believe the intent was to send them out on our provider listserv.
Okay.
But they would also go, they'd also be posted with materials for the commission meetings. And so
right.
Sometimes judicial officers or OJD representatives comment on those or submit public comment, but I'm not aware of any current plan to share them with the courts, but that could be considered if that would be helpful.
I'm not suggesting it's a good idea.
Okay.
I'm just suggesting that I'm just curious of what would happen if it were to, if they were given the opportunity to provide feedback.
Got it. Okay. All right. Well, as always, thank you all very much, and I'll send out updates and emails shortly. Have a good Tuesday.
Thanks, all.
Thank you.